Good evening, everyone. I am C. Amita Bissa, moderator of this webinar. We are delighted to welcome you all to the webinar being organized by Commercial Law and Economic Advisory Committee, that is CLEAC of ICAR. It is my pleasure to be the moderator for today's webinar on copyright, understanding the framework of copyright law in India, scheduled on 23rd April 2026 from 5 p.m. to 7 p.m., organized by CLEAC Committee of ICAR. Before we commence, I would like to start giving a brief introduction about our committee, CLEAC. This committee is focused on encouraging chartered accountants to shape strategy and policy that unlocks economic, financial, and social values while combining analytical foresight with commercial acumen. One of the core areas of the committee is to serve the multifunctional task of analysis and knowledge dissemination, providing inputs to regulators and policy formulation, developing and publishing technical guidance and background materials, creating awareness on professional opportunities for chartered accountants in the domain of commercial law and economic advisory. Now, it's a privilege of mine to give introduction of our eminent speaker for today's seminar, Ma'am K. Ankita Rao. She is Assistant Professor Law at ICFAI Law School, IFHE, Hyderabad. She has strong academic background. She did her BA, LLB honors, and LLM in IPR laws. So we are delighted that we have experts with copyright with us today. She will be sharing her insights on copyright, understanding the framework of copyright law in India. Before I hand over the session, please note, or at the end of the deliberation, we will be having Q&A question and answer session. Participants are encouraged to raise their queries, which will be taken up by the moderator and addressed by our learning speaker. Now I hand over the session to our learning speaker. Over to you, ma'am.
Good evening, everybody. I hope I'm audible, visible properly. Can somebody please confirm if I'm audible and visible?
Your screen is freeze, coming in chunks, like it's not fluid in a flow. It's getting freezed.
I am not audible properly. Am I now?
Yeah, now you're audible.
Just give me one. Okay, am I audible now? Actually, there's a lot of rain in Hyderabad today. So probably the network connectivity will come and go. So please bear with me on that. Yes, so just let me share my screen and then I'll start. Okay, is the screen visible properly?
Yeah.
Mita ma'am, is it visible?
Yeah, it's visible.
Okay, okay. Good evening, everybody. So, I will be taking this session on introduction to copyright today. And before moving into the intricacies of it, just a brief introduction of what copyright generally means. So, copyright is basically a bundle of rights, okay, which is given to a person who puts in his creative labor into creating something which is original in nature. So, in the span of the next 2 hours, we are we will be trying to understand uh, the entire law behind copyright, not the entire law probably, but the most important aspects of copyright law. And before that, it is very, very important for us to understand a brief history of how copyright came into picture in the first place. So, if you look at it, um, the idea of copyright, like we understand it today, like we understand it in the modern sense, that uh, that was not in existence before uh, the invention of the printing press. Now, this printing press was invented in the year 1436 in Germany, and this was invented by Johannes Gutenberg. Now, before the invention of this printing press, if you look at it, the literary works were copied manually by the way of scribes. People used to write down all of these books, and it was very difficult for people to create copies of these books because there was a lot of labor that had to go into it then. So, duplication in that respect, since it was a mechanical process, it was very, very slow and also limited in nature. So once this printing press was invented, uh, it enabled mass reproduction of uh, books, which sort of created an economic value of copying. So when this technological shift happened, uh, the concern initially was not to protect authors, uh, since at that time everything was related to economics. So the earlier efforts were not essentially to protect authors, but the earlier efforts were to protect these printers and the booksellers who invested a lot of money, invested a lot of capital into producing these books. So, as a result of this, what happened was the earlier protection of copyright, if you look at it, was not very author centric, but earlier we gave printing privileges. Now, what do you mean by printing privileges? Printing privileges, just like copyright, are exclusive rights, which are again granted by authorities itself, but it was to print certain books and not to create the books. So authors were not getting these exclusive rights; printers were getting these exclusive rights. So again, since the invention of the printing press happened in Germany. So Germany was among the first countries to grant these privileges. And at this time, printing was also spreading across the entire Europe. So sort of similar systems also emerged throughout Europe. Now, if you look at England, uh, in England, the earlier phase was relatively more open. Open in the sense that in around the 15th century, there was this king called King Richard III, and he allowed all of these foreign people coming from the foreign lands to import uh, to import books and then print these books in England. So, as a result of this, if you see, uh, although England became sort of a printing hub at this time, sorry, did it move? I'm really sorry. Yes. So, although England became sort of printing hub at this point, but majorly all of this printing was being done by people who were coming from foreign lands. So this meant that most of the trade that was going on in England was more dominated by people from foreign lands. So the crown started to realize that this is an issue, because most of the economy was concentrated in the hands of foreigners, so which was an issue, and therefore the crown, they started to tighten a little bit of control in this regard. So when King Henry IV came up, he placed certain restrictions uh, which ultimately led, so he started placing restrictions, but all of these restrictions put together at the end led to a complete ban on importing books altogether. So then came the Stationers Guild through the Royal Charter in the 1556. And the Stationers Guild was excessively important because they maintained a register of books, which was sort of an early copyright protection if you look at it. Then they also controlled how printing was happening throughout England, and they enforce certain rights relating to search and seizure, especially of unauthorized copies. So this system, it essentially protected all the publishers, and not so much protection was given to the authors in this regard. So copyright started to become essentially a monopoly of intermediaries, which was backed, of course, by the crown also. Now, post this, if you look at it, there was this uh, very first modern copyright regime, as it is called, uh, the Statute of Anne. It was introduced in UK. Now, the Statute of Anne uh, essentially started to shift from a publisher controlled monopoly to certain author centered rights. Not, of course, not everything was author centered, because, of course, they had to also maintain the monopoly of UK. But then, uh, sorry, they had to maintain the economy of UK, but certain rights were shifted from the publisher controlled monopoly to now started to shift to author centered rights. Also, before this, whenever copyright was protected, it was sort of a perpetual protection that was given. Under this system, also, it was not explicitly mentioned that it is going to be a limited period protection. However, post this, there was a post the Statute of Anne, there was this very, very important debate that came about, which was whether copyright uh, is to be protected under the common law, which gave a perpetual sort of protection, or we are now going to give a statutory copyright protection under the Statute of Anne, which is sort of going to provide limited protection. So the first very important case in this regard was Miller versus Taylor. And in this case, if you see, there were four different judges, but three of them, instead of actually answering whether copyright protection should be a limited period protection, they started to justify why copyright protection was to be given. So one of the judges said that because copyright satisfies the labor theory. The labor theory basically says that whenever you apply your labor to any property which is generally existing in nature, you get to bear the fruits of it. So you get to enjoy the fruits of it. So according to the labor theory, the ideas which, if you apply the labor theory to the copyright law, the ideas which are existing naturally in the environment, if you apply your labor to those ideas and sort of bring something creative out of it, uh, it should be protected as an exclusive right. Okay. Another judge said that because it also satisfies the incentive theory, we should now protect it. What do you mean by the incentive theory now? The incentive theory says that you should incentivize people who are doing any sort of creative work, so that uh, the upcoming generation sort of have an encouragement that they should go ahead and they should also uh, uh, make these creative works, so that later on they are also incentivized, they are also given these exclusive rights through uh, which they can economize basically, right? Then there was this another judge who said that it also satisfies the natural rights theory. Now, natural rights theory says that if anybody is applying their mind to sort of make a mental creation, they should own it. Whenever anybody is creating something, they should be the ultimate owner of it because it is naturally right to do so. So, all of these judges, this was a 1769 case, all of these judges, they did not answer whether copyright should be uh, uh, limited, have a limited term protection, or should it be perpetually controlled. Uh, but they sort of justified why copyright should be protected in the first place. Now, another important case, uh, which was a case of 1774, which was Donaldson versus Beckett. In this case, the court made it very, very clear that now that we have a statute in place, copyright protection is only going to be limited in nature. Now, another reason, if you look at it from copyright perspective, copyright has two very important aims that it likes to, or that it wants to achieve. Okay, the first aim is, of course, since the author is creating a particular work, so incentivize the author, give some exclusive rights to the author in that regard. And the second is that the ultimate aim of copyright is for people to have access to knowledge. And that is why we have something called the public domain. Now, what is the meaning of public domain? What are the elements of public domain? All of these things are very, very debatable. There are several research papers written on it, but I am just going to tell you a gist of what public domain means. So, public domain is basically a, a sort of a place where all of these works, which are protected by copyright at one point in time, they fall into this domain after the copyright protection in it has expired, or whenever any person does not have to take the permission of the author in order to be able to use this work. So, copyright public domain is basically that area in copyright wherein people do not have to take the permission of the author in order to be able to use the work, right? So, copyright has two aims. One is, as I told you, give exclusive rights to the author, and two, at the end, ensure that the general public at large, has access to these works. Okay, now how do you ensure that the public has access to these works? Only once a copyright term of protection expires will the public be able to use these works without any restriction. And that is why in Donaldson versus Beckett, or understanding that copyright needs to, all these works needs to fall into the public domain at one or the other point in time, the judges said that copyright is going to be uh, it is not going to be perpetual in nature, but is going to be limited term protection. Then after all of these years, uh, and after evolving through several statutes, uh, the Copyright Act of 1911 came in England, and this was a consolidated sort of a copyright act. So what it did was it codified the copyright law. One, all the earlier statutes, which sort of were a little bit problematic, did not uh, protect copyright to a very great extent. They all were repealed using this particular law. And they also abolished the common law copyright completely. So common law copyright was abolished completely. It had absolutely no standing post the coming of 1911 Copyright Act in England. Now, another important aspect is, of course, the United States of India. Because US, if you look at it, most of the IP regimes in the entire world, you always go to US and see what US is doing with it. So patent also, copyright also, even plant variety protection for a very long time, we have looked towards US to understand what kind of protection they are providing. Because US has at least after the introduction of the TRIPS agreement, it has been very pro regime. So we have always looked at US from the perspective of IP rights to see how they are protecting certain things. So when you look at US, uh, after the American Revolution, which was in 1776, US started to develop copyright from a very, very nationalistic perspective. um, and in 1790, they enacted their statutory copyright law. A lot of inspiration was, of course, taken from the English law, but this English law was to a lot of extent tailored to suit the American conditions. So, US decided from the very beginning that they want to go for a statutory right itself. If you look at India, India's history, uh, since we were a colony of the British for a very, very long time. So of course, our statutory law was very, very inspired from from the Great Britain. So our first copyright law was under the East India Company in the year 1847, and post that, uh, we s- we extended the 1911 statute, which was in Britain at that time. We extended it to the Indian territory in 1911 itself. Post that, we understood that the 1911 law is not suiting the Indian conditions completely. So, with certain modifications, we again enacted the 1914 Indian Copyright Act. And the last, which we have currently in place, is the 1957 Copyright Act, which basically was enacted by independent India, and it still is the backbone of the Indian copyright law even today. Right. So this was about the history of the Copyright Act. Now, let us very quickly look at certain international instruments that we have in place. Uh, now, the first and the foremost is the Berne Convention of the 1886. Uh, uh, the complete name of the convention is the Berne Convention for the Protection of Literary and Artistic Work. Now, Berne Convention, if you look at it, it was one of the very first international instruments which came about in the year 1886, and it basically served as a foundation for the entire copyright regime throughout the world. Berne Convention said that there is going to be automatic protection, which means that you do not require a registration for copyright protection. You do not have to, like patent protection, patent can only be protected when you go and register for a patent. Copyright is not so. Uh, as and when a work is created, your protection starts. So, Berne Convention provided for automatic protection, then reciprocal protection. If your work is being, since these are between countries, right? All of these treaties, all of these agreements are between countries. Reciprocal protection means that if India's work, one of India's authors' work is being protected in the US, India would also have to protect the works of the authors of US. So this is a reciprocal protection. And then it also provided for a minimum term of protection, which was life plus 50 years. Okay. So this was the Berne Convention. I'm giving you very brief of it. Berne Convention has a lot of intricacies. So if we have to discuss the Berne Convention completely, we'll require 3, 4 sessions. So that is not possible. In fact, each of these treaties that we are discussing, they are broader topics in themselves. So it is not possible for us to be able to discuss all of these instruments in detail. However, we're just trying to understand what are the most important aspects of it. Then if you look at the agreement on trade related aspects of intellectual property law, uh, this was a 1994 treaty, but before that, let us come to UCC. Why? Because UCC was developed by one, UNESCO, and two, Berne Convention was sort of very, very strict in a lot of senses. So many countries did not want to sign the Berne Convention at all, and therefore Berne Convention was not that great a success. Uh, but if you look at UCC was more flexible. So UCC was nothing, but it was a sort of a flexible alternative for the Berne Convention itself. Uh, so it also required automatic protection, but no sort of formalities were again required under UCC. Then, if you look at some of the key features of the UCC, uh, they talked about recognition through notice. Now, what do you mean by recognition through notice? So UCC allowed that copyright protection should depend on a simple notice. If I have uh, created a particular work, I give a notice to the registry of the country, and my work starts to get protected. Then another was national treatment. Uh, but national treatment again was a little weaker than what was protected under the Berne Convention. So as I told you, UCC was a little more flexible and a little more easier option as compared to Berne Convention, and therefore uh, many more countries came ahead to adopt UCC in place of Berne Convention. Now, post this, we had the Rome Convention. Now, Rome Convention was for related rights. Related rights are rights of performers, rights of producers of phonograms, and rights of broadcasting organizations. These are not specifically copyrights; they're protected under the copyrights regime, but not as a copyright. They're protected as a special right. Again, when we look at related rights in detail in the coming slides, we will understand it better. But then we had the Rome Convention in 1961. Post that, we had the Agreement on Trade Related Aspects of Intellectual Property Rights, which was the TRIPS Agreement. Now, one very important provision of the TRIPS Agreement was it said that whichever country is signing the TRIPS Agreement, irrespective of whether they are a party to the Berne Convention or not, they they are going to adopt certain provisions of the Berne Convention. So it was made mandatory for all the people uh, who basically were parties to the agreement on trade related aspects, which was the TRIPS agreement. If you are a party to the TRIPS agreement, certain aspects of the Berne Convention you will have to adopt in your country. Now, many countries, they were very keen on adopting the TRIPS agreement. The reason was it was relating to the trade related aspects. And by this time, in the early 1990s, most of the countries throughout the world, they had started to realize how important it was to involve intellectual property in your trade, and not just your national trade, but your international trade also. So this was a very important agreement, and most of the countries wanted to become a part of the TRIPS agreement. So therefore, they had to adopt a few provisions which were there in the Berne Convention. And now TRIPS basically involved all of the major provisions which were there in the Berne Convention with respect to copyright. It involved all of those provisions and said that the parties who are adopting the TRIPS agreement, irrespective of whether they are parties to the Berne Convention or not, should adopt all of these provisions. Then we had the two internet treaties which came about in the year 1996. One is WCT, the other is WPPT, WIPO Copyright Treaty, and WIPO Performers and Phonograms Treaty. Uh, so both of these treaties were specifically aimed at addressing digital challenges, because by this time we already had television, internet started to creep in by this time. So more and more awareness uh, was starting to be created with respect to how copyright is being used in the digital era now. So WCT and WPPT with respect to copyright, WCT was there, and with respect to related rights, which we just talked about, the special rights, WPPT was there. And then we had the Marrakesh Treaty in the year 2013. This was specifically to facilitate access of the work. As I told you, the ultimate aim of copyright is to help people get access to these works. So in 2013, the Marrakesh Treaty came in order to facilitate the access of these published works for persons who were uh, specially abled, in the sense that they were blind or they were print disabled. So they were specially abled people. So Marrakesh Treaty had certain provisions in it in order to ensure that even these people, either blind or who are print disabled people, they should also be able to read the copyrighted works, and how it was to be done. It is provided in the provisions of the treaty itself. Okay, now coming to the actual copyright law, the first is to understand what is the subject matter of copyright. Uh, in India, if you look at it, we have Section 13, which talks about the subject matter of copyright. And Section 13 gives us 6 different uh, categories of work which are supposed to be protected under the copyright regime. So if you look at the Indian Copyright Act, these are the 6 works that are laid down. 1, 2, 3, 4, 5, 6. 6 works are laid down under the law itself. So anything which does not fall within the scope of these 6 works is not going to be protected by copyright. This form of a protection is called a closed list protection. Okay, so we have a closed list, a list of 6 things which are going to be protected in copyright. But do all countries have a closed list protection? No. Some countries like France and Germany, they have an open list protection. What is an open list protection? They have said that anything which is a creation of a human mind is going to be protected under copyright law. So now this gives a very, very broad perspective, a very broad idea of what is going to be protected under the copyright regime. Now, again, coming back to India, India says 6 things. So in the legal language, we call it LDMACG CF. Okay. Sorry, LDMA, CF, and SR. This is what we call it in the legal language, which means L stands for literary work, D stands for dramatic work, M starts for musical work, A starts for artistic work, CF stands for cinematograph film, and SR stands for sound recordings. 6 categories of works: literary works, dramatic works, musical works, artistic works, cinematograph films, and sound recording. Now, again, if you look at Section 13 of the Copyright Act, it says that original literary, dramatic, musical, and artistic works have to be protected. Cinematograph films have to be protected, and sound recordings have to be protected. Now, let us understand the intricacy of it a little. Uh, Literary work, anything that is written down, is a literary work. Now, dramatic work is a drama that you see, right? The stage shows that are put up, the drama that is there, all of those are dramatic works. Then we have musical works. Musical works are basically the music devoid of lyrics. Why? Because lyrics forms a part of the literary work. Because these are words put down in writing. So these are uh, literary works. The lyrics of a song are literary works. So a song devoid of the lyrics, only the musical aspect of it are musical works. Then you have artistic works, any painting, any drawing, any photograph for that matter that you take are all artistic works. Okay, any sand painting that you may do are all artistic works. Cinematograph film and sound recording, these 2 categories of works are composite works. What do you mean by composite works? Composite works are a group of these different kinds of works which have already been protected. The group of these 4 different kinds of works: literary, dramatic, musical, and artistic work. So if you talk about a cinematograph film, there is a script that is in place. right? And therefore, the script is a literary work. But when it is made into a cinematograph film, it also becomes a part of the cinematograph film. Second, there is background music in the movie. There are songs in the movie in which musical works are also a part of. Then you have artistic works. There are statues that may be used in a movie. There are paintings that may be used in a movie. So all of these things put together make up a cinematograph film. Why is a cinematograph film protected? Because there is a lot of investment that goes into a cinematograph film, uh, and the producers need to be incentivized in order to create these films, and therefore now we have started to give copyright protection for the films. Then we have sound recordings. Sound recordings are also composite works. Sound recordings are nothing but songs in the form of a recording, maybe in the form of a CD or in a form of any other sort of recording. So these are called sound recordings. Why we are protecting sound recording? Again, the reason is the same, because there is a lot of investment that goes into it, and we are trying to protect that investment through the copyright regime. Now, sound recording again is a composite piece of work because there are songs. So songs are musical works plus literary work. Uh, so therefore, and there are of course performances by the singers also. So all of these things put together become a composite work. Why the word original has not been attached to cinematograph films or sound recordings? The reason is because cinematograph films or sound recordings cannot be original in nature. These works are, since these are composite works, they are going to be a culmination of different original works. But when they become a culmination, that culmination itself is not original in nature. And therefore, the word original is not added to either cinematograph films or sound recordings. When you look at Section 13 says original literary, dramatic, musical, and artistic works. Then the second category is cinematograph films, and the third category is sound recording. This is how it is protected. This also brings us to another important aspect, that in India we have uh, only one thing that is required in order to give protection to copyright, which is originality. Okay, we have absolutely no other criteria, nothing else that tells us which work will be copyrightable and which work will be not. So only one category of works, which is original works. Originality is the only criteria for protection under the Indian law. Now, if you look at US, if you look at other countries, specifically US, you will see that there are different criteria of protection. For example, US has originality plus fixation. So not just originality, but you also have to fix your work in a material form. In India, that is not the requirement. You do not necessarily have to fix the work, you only have to create the work. Okay. The other problem is, then if you don't fix the work, how do you prove it in the court of law? Proving is a different thing. When you go to the court of law to prove it, that is a different thing. But under law, what is protected is an original work, also in an unfixed form. Okay. Another important aspect of copyright is that copyright does not protect ideas. What copyright is trying to protect is original expression of these ideas. That is why when you look at it, many movies have the same storyline, as in there is a boy, there is a girl, they fall in love, then there is some problem that is created, and at the end they are reunited and they live happily ever after. uh, if you look at Bollywood, 70% of Bollywood movies are going to be based on this theme. This is a broader idea. How do you express this idea into your work is what is protected by copyright, and therefore all of the different expressions that are there with respect to this broader idea of a love story, all of those expressions are protected by copyright. Um, Also, copyright does not protect any sort of facts. So, for example, uh, we went for an Operation Sindoor against Pakistan. Now, this is a fact. Okay. So copyright does not protect this fact. However, uh, if there is again another movie that is made on um, how Operation Sindoor was conducted, for example, Uri, we have seen. So it is a movie based on how the surgical strike was done against Pakistan. While it is a fact, there is creative liberty that is given in Bollywood, and that creative liberty uh, brings about different expression of ideas. And those expression of ideas are again protected under the copyright regime. So if tomorrow there is a movie made about this particular Operation Sindoor, then that is going to be protected. However, the fact that Operation Sindoor happened, that cannot be protected under the copyright law. Okay, then the term of protection, I have also mentioned it in the later slides, but just to give you a brief idea, in India, if you remember, Berne Convention had asked for a minimum term of protection, which was life plus 50 years. That does not mean that we cannot give more protection than that. Minimum life plus 50 years has to be given, but there is no bar on providing a better protection than that. So India provides a better protection in the form of life plus 60 years of protection. Uh, then certain these illustrations I have already told you, literary works would basically have any sort of poems or any sort of novels, any books, all of these things written down, lyrics of the novels, scripts of cinematograph films, all of these are literary works. Musical works are the music, the jazz, any sort of improvisation that you do in the music, all of these, the symphonies that are there, all of these are musical works. Choreographic works are part of dramatic works itself. So any sort of choreographic works like any dance move or any ballet move, all of these would come under dramatic works. Then artistic works, I told you, paintings, engravings, or sculptures, all of these are artistic works. Photographs fall within the ambit of artistic works itself. And another important aspect, computer programs, they fall within the ambit of literary work. The reason is we do not protect the computer program per se. What we protect under copyright law is the code of that computer program. Since the code is written down, it becomes a literary work, and therefore the computer program protection of computer program under the copyright law is provided within the category of literary works itself. Now, I told you that the only criteria in India to protect any work uh, is the criteria of originality. Now, what is original and what is not? There are three tests to determine. The first test, which was earlier, now it does not exist anymore. The test was sweat of the brow test. Sweat of the brow test is nothing but if you are applying your labor to a work, that work becomes original as it is, because the labor has to be rewarded and therefore should be protected under the copyright regime. However, this test does not exist anymore. We do not protect copyright by way of sweat of the brow anymore. Now what we have is modicum of creativity. Modicum of creativity uh, basically means that we do not look at originality in the sense how we look at novelty under Patents Act. Novelty under Patents Act is something that should be unheard of. You should have never heard or seen that particular thing. So it should be completely new. In copyright, however, what we are talking about is not novelty, but originality. So originality uh, is brought about by a simple creative process also. So simply something exhibits a little bit of creativity also, that can be protected under the copyright regime. It can be called original in nature. The third and the most important test is the skill and the judgment test. How much skill of your mind and how much judgment have you applied to bring about a particular piece of work? For example, even different compilations are protected under the copyright law, but then you have to see how much skill has been applied in order to see which work should come first in the compilation, which work should come second. Is there any skill or any judgment that has been applied in order to decide the same? Or are we uh, just randomly picking up things and randomly making a compilation of it and trying to protect it under the copyright law? So this is a skill and the judgment test. Now, two very important concepts under the copyright law are the concept of authorship and the concept of ownership. Authorship is basically who has created a particular work, and ownership is who has the rights relating to a particular work. Might you might when you look at these two terms, you might think that these two terms are more or less looking the same, but it is not so. And we are going to understand it through the sections which are provided under the copyright law. Now, section 2D of the copyright law says that uh, the author of a work will be as follows. So in case of a literary work, the author is going to be the author. Now, this is a little tricky to understand. Author is a author means anybody who has written it down is the author. Okay. In case of a drama, the person who is a dramatist is going to be the author of the work. In case of music, the composer of the music is going to be the author of the work. In case of artistic works, if it is a painting, then the painter. If it is sculpture, then the sculptor. If it is an architectural work, then the architecture of it. These are going to be the author of that particular work. Then in case of photograph, the photographer is going to be the author of the work. Now we are still talking about authors of a work, okay? We're not talking about whether these people will hold all the rights pertaining to that particular work. We're only talking about who is the author. Whether the author will hold the ownership or not, that we will look at in the upcoming section. Currently, we are just looking at who is going to be the author in a work. Then in case of a cinematograph film and in case of a sound recording, as I told you, since there is a lot of investment that is made by the producer, therefore the producer is going to be the author of both of these, the cinematograph film and the sound recording. Now let us come to section 17, which talks about ownership of copyright. Now we have looked at who is the author going to be. Section 17 says that in normal circumstances, the author is going to be the owner of copyright. Owner of copyright as in the person who holds all the rights in particular work is the owner of the copyright. So in normal circumstances, the author is going to be the owner as per Section 17 of the Copyright Act. However, Section 17 also lays down certain exceptions to this general rule that the author is going to be the owner. What are these general rules? What are these exceptions? The first is the work created during employment. Now, for example, I have a company and I am hiring an artist to create paintings for my company. In this situation, the author of the work, who is the painter in this scenario, that person is already being paid from my company, right? And he has been hired to make these paintings in my company. Therefore, all the paintings that he will make are, maybe he is the author. He is going to be the author, not maybe. He is going to be the author in the work. However, my company is going to be the owner of that work. Okay, this is the first exception. The second exception is any work which has been created on payment or commission basis. For example, you have artists who create these sculptures, right? However, they are given a commission, and the person who is giving the commission becomes the end owner of that sculpture. The third is any newspaper or any magazine work. If there is a newspaper which is hiring you in order to write an editorial for them or in order to click a photograph for them, all of these works are the works of the newspaper itself. Then you have a government work, any work that is being created because the government has asked you to do it and the government has hired you to do it, then the government becomes the owner in that situation. Similar is the case with public undertaking and international organizations. If any public undertaking or any international organization, they have hired you in order to do a particular task for them, in the sense of making any of these six types of work for them, then uh, uh, the work that is created is going to be owned by this public, either this public undertaking or this international organization. Now, there's also a concept of joint authorship. What do you mean by joint authorship is two or more people making the work together. Now, in order to be joint authors in a work, there are two requirements. One, there should be more than one person working on that work. And two, that you should not be in a position to be able to separate work, what part of this work has been done by person A and what part of this work has been done by person B. So these works should be so intertwined that it is almost impossible to separate them. Um, One very, very important case law which has happened in this regard, which was called Najma Heptullah versus Messrs Orient Longman Limited. In this case, there was a book titled India Wins Freedom, which was written by Maulana Abul Kalam Azad. And this work was basically, it was a work. It was a consolidation of the experiences that were shared by Maulana Abdul Kalam Azad, and it was written in collaboration with Kabir. Now, Maulana Abdul Kalam Azad, what he used to do was he used to sit and he used to narrate all of these experiences that he had during the freedom struggle of India. And Kabir used to note down and take down these points which were given by Maulana Abdul Kalam Azad. Now, after taking down these points, he would go back home and he would think about how to elaborate on these points, which point to include in the book, which point to not include in the book. And ultimately, he came up with an entire book. Now, Abdul Kalam Azad was given a copy of this book. He read the entire copy, made edits to it, and made certain additions, made certain deletions. And at the end of the day, both of them together, Maulana Abdul Kalam Azad and Kabir, they both decided that only a part of this book was to be released. The other part, they agreed that it should only be released at least 30 years after the death of Maulana Abdul Kalam Azad. Now, the first part of the book was released with no problems, of course. And post that, Maulana Abdul Kalam Azad died. 30 years after his death, Kabir decided to release the second part of this book. However, the problem here was that after his death, the legal heirs of Maulana Abdul Kalam Azad, they said that that it was also a work of Maulana Abdul Kalam Azad and they did not want to release it. Okay, so this question went to the court of law whether they both are joint authors in the book or they are not joint authors in the book. And the court said that since the works of both of these people are very, very intertwined, one was narrating the experiences and the other was writing down the experiences, but the other person, which is Kabir, he also used his own skill and judgment in order to elaborate on the events. One, uh, decide which parts of the narration had to be deleted, which parts of the narration had to be kept. All of these things were decided, and therefore a lot of skill and judgment was exhibited by Kabir in this regard. and therefore both of them were held to be joint authors. However, the legal heirs, which was Najma Heptullah was none other than a legal heir of Maulana Abdul Kalam Azad. She claimed that Maulana Abdul Kalam Azad was the sole author of the book. Why? Because it was him who had narrated the fact, and Kabir had just scripted it out. But the court said that Kabir has not just mechanically scripted the book work. What he has done is he has applied his skill and judgment. He has applied modicum of creativity in order to elaborate on the facts and in order to decide which facts were to be included and which facts were not to be included. Now, another case, if you look at it, is a monkey selfie case, very, very prominent case in the copyright regime. It was a case relating to how a monkey uh, has taken a photograph in a jungle. Now, there was this one particular person who went with a camera and he wanted to do wildlife photography. So he went with a camera to a jungle and he placed the camera in the jungle itself. Now he went here and there, and the camera was on recording, so it was recording different aspects of what the animals were doing in the jungle. However, then this one particular monkey, as you can see in the picture, he came near the camera. It came near the camera, and it started to click pictures of its own. Okay. As per the Copyright Act, author of a particular work, for example, if you remember who was the author of a particular photograph, the author of a photograph is the person who had clicked the photograph. So now in this scenario, can a monkey become an author, was the question before the court of law. And this was the first time when the court said that we are not going to recognize non-human authors, which is still the case in most of the countries. And uh, this case has been seen as one of the building blocks for deciding whether we will now start to recognize uh, AI generated works or not, or uh, do we recognize AI as authors in this regard or not? So this was one of the cases. The second case was with respect to Rogers versus Coons, which basically talked about whether we have fair use. So when we talk about fair use in detail, we will talk about Rogers versus Coons, because this particular case will not make a lot of sense here. Then the next aspect is the term of copyright. For how long is a copyright protected? So if you look in India, the LDMA works, which are the literary, dramatic, musical, and artistic works, except for photographs, which forms part of the artistic works, except for photographs, all of these four works are protected for the lifetime of the author plus 60 years post the death of the author also. Okay. Next, if there are any anonymous or pseudonymous works, anonymous works are where the author is unknown. Pseudonymous works are where the author has used a pseudonym uh, uh, to protect the work. To bring the work out in the market. Then it is a pseudonymous work. You have a posthumous work. Posthumous works are works which are released after the death of the author. Then photographs, cinematograph films, sound recordings, all sorts of government works, all sorts of works of public undertakings, and all sorts of works of international organizations. All of these, the term of protection is 60 years from the date of publication. Then in case of broadcast reproduction rights, which is again a related right, again we will see what these rights mean. The term of protection is 25 years from the next calendar year. So if the broadcast has happened in this year, we start from 1st January in the next year and calculate 25 years. Uh, with respect to performers' rights are going to be protected for a term of 50 years. Now comes the very important aspect of what are the rights which are provided under the Copyright Act. Now, there are several rights. As I told you, copyright is a bundle of rights. So there are several rights. If you look at the nature of these rights, they are statutory rights because they're provided under statute under the Copyright Act of 1957. Secondly, the copyright is a negative right. When I say negative right, it means that instead of giving you an exclusive right, what copyright is doing is it is prohibiting others from using your work. So it is a negative right in that respect. Then the third thing that it is copyright is a bundle of rights. So there are multiple rights which are associated with a singular work. Then there are two sets of copyrights. If you see, there are economic rights and there are moral rights. Okay, so economic rights are basically those rights which you can economize, and moral rights are, again, there are two types of moral rights that you may be able to see, which again we are going to discuss in much more detail. So we will look at it. Negative right, I have already told you. Multiple rights, I have already told you. Economic rights now. So economic rights of a copyright, economic rights in a particular work are mentioned under Section 14 of the Copyright Act. Section 14 says that these statutory rights, different sets of these rights are going to be provided for different sets of work. So in case of literary work, dramatic work, or musical work, the rights which are given are the right to reproduce, which means that to reproduce the work as it is, okay, to make a copy of the work basically. Then the second is to issue these copies to the public. Okay, so basically public dissemination of the work is also one of the statutory rights, one of the economic rights that is provided under Section 14. The third is to perform the work in public. So for example, it is a dramatic work. So you are performing the work. It is your right to perform the work in the public. Nobody else can take your script and then perform the work in the public. Then communication of the work to the public. Now, this communication may be through any means. It may be through broadcast, it may be through performance, or it may be through any other means. So basically, disseminating this work to the public at large, again, communicating this work to the public, again, your right. Then to make a cinematograph, film, or sound recording in respect of the work. For example, I have a script. It is a literary work, right? Now, to make a cinematograph film is something that I can do. It is my exclusive right. Or to put it in the negative rights sense, I am in a position to prohibit anybody else from making a cinematograph film on the script that I own. Okay. Now, how does it happen then in the practical world? How does it happen is there are script writers who write the script of a movie, then they license the script of the movie, or they assign the script of the movie to the producer, who is then able to make a cinematograph film. What is assignment? What is licensing? We are going to look at it. But just a general understanding, assignment is transferring of your entire right in a work to anybody else. So now they can sell, or uh, uh, they can reproduce the work. They can literally do anything with your work now. So you have transferred the entire ownership in your work to somebody else. License is allowing somebody a limited access to your work and a limited usage of your work. That is what you mean by licensing. So in the practical world, if I own a particular script, what I am going to do is I am going to allow these producers of these cinematograph films to take a license or take an assignment from me of this script writing, of this written down script, and then make a cinematograph film out of it. Okay. Then if I've written a book in English, say, and I want to translate it to Marathi, then even that is my exclusive right. Then the last is to make an adaptation of the work, which means that say I have written down how a sculpture is to be made. Then somebody else makes the sculpture for me. So basically adapts the work in a particular format. For example, there is a book. For example, Harry Potter was written as a book, and then it was adapted into a cinematograph film. So adaptation is nothing but change in the format of one work into another. That is what is adaptation. Communication to the public, I have already told you. Now, in case of computer programs, in addition to all of the rights that we have seen, another important right that has been provided to the authors of computer program is the right to sell or give on commercial rental. Okay, so commercial rental, as you can see, is nothing but giving somebody this particular computer program for rent. Okay, so you give this computer program to them and then take rent from them. So this is a commercial rental. You can't do it with respect to computer programs. Just give me a second. I think there's a message. Okay. So that is a commercial rental. Just give me 1 second. I'm just figuring out how to do this. Yes. Anyway, so now in case of computer programs, I told you just one more addition to the rights, which is the right to sell or give on commercial rental the computer program. Okay. Then the next that we have is artistic works. So in case of artistic works also, you have a right to reproduce, you have a right to communicate the work to the public, you have a right to issue copies of the work to the public, you have a right to include this artistic work in any cinematograph film, and you have a right to make adaptations of the work. Okay. Then in case of cinematograph film, the rights are a little different. Why? Because these are not original works, as I told you. So therefore, the rights are a little different. What are these rights? One, the first is the right to make a copy of the film. Even photographs that you take of a particular film, that is not allowed. So you go to a theater and you click photographs, that is not allowed. That is a copyright infringement. And therefore, when you go to watch a movie, you mostly find that it is written on the screen that you should not record or you should not take photographs of the film because this is a copyright infringement. Okay. The second is to sell or give on commercial rental. Again, you give the movie to somebody and take rent from them, and then they commercialize the movie further. That is not allowed. And then communication of the film to the public is the third right provided. In case of sound recording, again, it is the same uh, as uh, as CF if you look at it. So you cannot copy the sound recording and make another sound recording uh, of the same nature. The second is again commercial rental, and the third is to communicate the sound recording to the public at large. These were the economic rights. Now the other aspect of copyright is moral rights. Okay, so now moral rights are basically of three types according to different scholars. Now the three types of moral rights are: one, to decide the right to decide whether I want to publish my work or not. Secondly, the right of paternity, which is basically the right to claim the authorship in a particular work. If somebody is uh, uh, placing the work in the market, it should be written that the author of this work is so and so person. So, right to claim authorship of a particular work. And the last is the right of integrity. Okay. Now, right of paternity is also called the right of attribution. Right of attribution is if it is my work, attribute the work to me. Simply. Right of integrity is prevent people from altering or damaging your work. This is the right of integrity, to preserve the integrity of your work. Now, most of the copyright regimes throughout the world, they only protect two moral rights, which is the right of paternity and the right of integrity. The right to decide whether or not to publish the work, that has not been recognized under a lot of regimes throughout the world. Even in India, for that matter, we only have right of paternity and right of integrity, which have been recognized. Then one very important case law in this regard is Amarnath Sehgal versus the Union of India. In this case, uh, there was a mural that was created by one of the sculptors, and it was placed in the Vigyan Bhavan, New Delhi. Uh, until 1979, it was placed there. However, in 1979, the government decided that in the Vigyan Bhavan, we are going to carry out certain renovations. And during the renovations, this mural was removed from its original place. It was kept in the storeroom. It was actually not even kept in the storeroom, it was dumped in the storeroom. So, because of this mishandling, the mural lost its entire aesthetic appearance. Also, the market value of it degraded to a lot of extent. So this person, Amarnath Sehgal, who was a sculptor in this case, he went to the court of law claiming that I have certain moral rights which are attached to my work, which also includes the right of integrity, and therefore I should be paid damages for the infringement of my moral right. The court said, yes, there has been an infringement of your moral rights, and therefore a damages of 50 lakh rupees was awarded to him. Then the next aspect is the assignment and licensing aspect. Now, as I told you, assignment and licensing, assignment is nothing but transferring your entire ownership in a particular work to somebody else. Section 18 of the Copyright Act talks about assignment in a work, which says that you can either transfer transfer ownership partially or completely. There may be assignment may be general in nature, which means that there are not going to be any limitations with respect to geography, with respect to the extent of the work that is being transferred to you, or it may be particular with respect to certain limitations which may be involved. Okay. Then the third aspect is assignment may be for the complete term of copyright or for a limited period of time. And fourth, maybe on a territorial basis. For example, I have a work in place, so I only tell the other person that I am transferring my rights in the United States of America to you. In India, I am still going to hold the rights of the book. So you can sell, you can do whatever. You can use my work in any way possible, but only in the United States of America. In India, I am still going to go ahead and use my work, and I am still going to go ahead and commercialize my work. That you cannot do in India. Then section 19 talks about the mode of assignment. So whenever there is an assignment that is being made, the first thing that you need to remember is that the assignment needs to be in writing. Okay. And it should be either by the assigner itself, the signature should be either by the assigner himself or by his duly authorized agent. So the assignment, the next aspect is that the assignment should also first identify which work is being assigned. There are tons or crores of works out in the open. So the assignment deed that you are making, the first and the foremost thing is that it should identify which work is being assigned, as in whether it is this book or whether it is a cinematograph film or whatever. The title of the work should be written, and what are the specific rights which you are transferring the ownership of to the other person. So we have looked at how copyright is a bundle of rights. Under assignment, you can transfer all of these rights altogether to another person, or you can transfer only one right to another person, which is very much possible. Okay. Then what is the duration of your assignment? For how long are you assigning this work to the other person? And in which territory are you doing it? All of these things are to be mentioned in the assignment. Now, another important thing that should be mentioned in the assignment is the amount of royalty that needs to be given. Okay. Section 19 talks, Section 19 in the latter half says that if any person who has been given these rights in the form of an assignment, they do not exercise these rights within 1 year from the date when the assignment was given to him, then we are going to consider it as a lapsed assignment. So you have to use the work if you have taken the assignment of the work. If until 1 year you are not using the work or you're not exercising your rights, then post 1 year, we will consider that the work has lapsed. Okay. If the period is not mentioned in your assignment, then we are going to consider 5 years. Technically, 5 years is the period of your assignment. So if you're not going to mention for how long is your assignment going to take place, we are going to consider only 5 years. Third, if you're not going to mention what is the territorial extent of the transfer of your work, then we're going to presume that it is for the territory of India. Now, before going into relinquishment, under section 18 and 19, another very important aspect was the right of inalienable royalty. Uh, Inalienable right of royalty, which means that um, as I told you, cinematograph films and sound recordings, these are two composite works. Now, there are several different authors which make up who are the authors of the work which make up this composite work. For example, there is going to be a script writer who will write the script. There is going to be a lyrics writer who is going to write the lyrics. There is going to be a music composer who is going to make up the music. There are going to be actors who are going to be performers in the movie. So all of these different authors are also there, right? And just because the producer is the ultimate owner of the cinematograph film does not mean that the producer is going to become the owner of the script, right? Of the script or of the lyrics of the song or of the musical work of the song. The producer still does not become the owner of all of these things. Okay, the underlying authors, which is the script writer or the lyrics writer or the music composer, they are still going to hold rights with respect to all of these underlying works. What section 18 says is, even if these authors of the underlying works, they do not want to take the royalty from the producer, they will still have to take the royalty from the producer for any commercialization of the film that happens. Why this had happened? Because earlier producers used to be in such a strong bargaining power that they used to suppress all of these script writers and all of these music composers and all of these lyrics writers, and they used to force them in order to give the assignments and licenses of these works at very minimal costs. So it was sort of an exploitation of the authors of these underlying works. Mr. Javed Akhtar was the one who realized that there is a lot of exploitation that is happening. And that is why he was the one who pushed for this amendment, which happened in 2012, by which the inalienable right to royalty was included under Section 18 and Section 19 of the Copyright Act. So, again, that is a very important aspect. Then, another important aspect is the relinquishment of copyright, which is provided under Section 21. Section 21 says that if any author does not want to uh, hold the copyright and wants that his work should be out in the open for everybody to use, he is free to relinquish his own right, which means to give up his right in the work altogether. He will not hold any right post this. and his work will be considered to be relinquished. His rights would be considered to be relinquished. Then, since there is paucity of time and we are running out of time, what I will do is I will tell you the basic meaning of license, and we are not going to go into the different types of licenses which are there. Okay. The most important type of license is provided under Section 30 of the Copyright Act, which is a voluntary license. A voluntary license means nothing but that I want certain rights in my uh, work to be transferred to you for a limited period of time. Okay. Now, when I am transferring these works to you, that does not mean that I am not the owner. I am still the owner of those rights. However, I am allowing you to use the rights. In assignment, I was transferring the ownership of the entire right to you. This is the exact difference between licenses and assignment. Assignment is the transfer of ownership. License is not the transfer of ownership. License is merely a permission for you to use the work without my permission. So it is merely sort of a permission that is given to you. Assignment is the transfer of ownership of my entire right to you. Now, either I can transfer the right or the ownership in one of the bundle of rights or in all of the rights altogether. That is upon me. Licenses is just a permission. Okay, so Section 30 I have mentioned that in case in any existing work or in any future work that I want to create, I can transfer any interest in that particular work to you. And again, this is only an interest in the work and not the ownership of any right in the work. It is only an interest in the right, not the right in itself. So license is an interest in the right, and assignment is the complete transfer of the right itself. Okay, this is the basic difference between assignment and licensing. Please remember this. Then we have compulsory licensing also, which is provided under Section 31, which says that if any work is not available for the public in the form of publishing the work, in the form of communication of the work through performance, basically, if it has been withheld from the public and the public does not have access to this work, then any person can apply for a compulsory license, and the registry is then going to say that, okay, now you take a license of this work and you take the responsibility of communicating this work to the public at large, so that there is access to this work that is given to the people. Okay. Okay, this case is not that important. We directly go to related rights and neighboring rights. As I told you, related rights or neighboring rights, both are parallel names of the same thing. They are basically three different types of entities which are given these neighboring rights. One is performers, the other is producers of phonograms, and third is broadcasting organizations. Okay. Now, all of these three categories of people, they are given certain rights which are not copyrights. The rights that they are given are special rights under uh, the Copyright Act. Now, when you talk about broadcast is either by wired means or by wireless means, uh, communication of a particular work to the public. Yes, so it is broadcasting the work to the public is broadcast. There are certain rights uh, which are provided to broadcasting organizations, which are provided under Section 37 and are called broadcasting reproduction rights. So only given for a period of 25 years. And the rights that are provided are first, rebroadcasting the broadcast. For example, there is a for example, in Hotstar, there are IPL matches now at 7 p.m. A match is going to start in Hotstar. Hotstar is what? Hotstar is a broadcasting organization which is broadcasting the match which is happening somewhere. Okay. Now, since it is a broadcasting organization, since it is broadcasting a particular match, to rebroadcast it later on is also the right of Hotstar only. You and me cannot rebroadcast that match later on some other platform. That is not possible. If Hotstar is broadcasting it in the first instance, it is the right of Hotstar only to rebroadcast it later. Okay. Then, uh, causing the broadcast to be heard or seen by the public on payment of charges also. For example, tomorrow you and I cannot cause this particular broadcast to be heard or seen by the people on payment basis. Okay, that is not possible. Then making any sound recordings or visual recordings of the broadcast, you cannot take a photograph, cannot record on your phone what is going on in the broadcast. Not allowed again. Okay. Uh, then making any reproduction of such sound recording or visual recording, such as initial recording was done without license or where it was licensed for the purpose not envisaged by such license, which means that you are making a reproduction of that. Basically, you're copying that broadcast without a license, you're copying it. And even if it is with license, your reproduction of the broadcast is not for the purpose for which the license was given to you. Okay. And then the last is selling or hiring the license, which is again selling or hiring the broadcast, which is again not allowed. Okay. Then you have the right of the performer. Now, who is a performer? As per section 2QQ, performer is again an inclusive definition. It does not tell you what performer means. It only tells you under the definition of performers, which are the different entities which are going to be included. So actors, singers, musicians, dancers, all of these people are going to be included, but they have to make a live performance. There was a lot of hue and cry with respect to what is the meaning of live performance. Does it not include any performance that is given in a studio? But then the courts have come to a conclusion that even studio performances will be considered as live performances. Okay, then section 38 provides for the rights of a performer. What are the rights of different performers? Again, remember, these are special rights. These are not copyrights. These are special rights that have been given to three different entities, not copyrights. So uh, when any performer he appears or engages in any performance, uh, please take a note of this word. He shall have a special right to be known as the performer's right and not a copyright. Okay. Performer's right, as I told you, uh, under this one of the heads where we were discussing the term of protection, the performer's rights are provided for a period of 50 years from the beginning of the next calendar year. Okay, what are the different rights that are provided to a performer? The first is to make a sound recording or a video or a visual recording of the performance. So you cannot record a performance when you go. I don't know if any of you have ever gone to see a theater play, which is basically a drama, but you're not allowed to either sound record or visual record the drama. Uh, it is an infringement of the copyright. Okay. And since you cannot record, you cannot also reproduce. You cannot also issue any copy of this recording to the public, or you cannot sell or give on commercial rental any of these recordings. None of these things you can do. Okay. And the second right is nobody without the permission of the dramatist can communicate the performance to the public. Okay, so the communication of the performance to the public is also an exclusive right of the performer itself. Then the performers are also given the two moral rights, the right of attribution and the right of integrity. Okay, for the performers also, these two types of rights are available. Then there are certain acts which do not infringe the broadcast reproduction right or the rights of the performers. So the first is making of any sound recording or visual recording for private use. Okay, so for private use, for research purposes, if you are making any sound recording or visual recording, then it is not going to be an infringement of these special rights. Remember, for copyright also, private use, research purposes have been provided, teaching purposes, all of these have been provided, but they have been provided in the form of fair use, which we are going to look at. Okay. The second is, if you are using it, if you're using only excerpts of the performance or excerpts of a broadcast in order to report the current events. Let us take an example. For example, you see that there is a Republic Day parade that happens. Okay. And the broadcast of it is usually, the original broadcast of it is usually on DD, right? But all of these news channels who are also showing us what is happening at the Red Fort, they are taking excerpts from the broadcast which is happening on DD. They're taking excerpts and they're telling us what is exactly happening. So they are reporting the current events, and that is why they are taking the excerpts of the broadcast from DD and showing it on their respective channels, right? So this is not an infringement of copyright because they're only using excerpts and they're using it for current events. Okay. Then the last is, if they are making any necessary adaptations or modification, uh, and those adaptations or modifications are allowed under Section 52 of uh, the Copyright Act, which talks about fair use, then these are not going to be infringing the broadcast reproduction right or the performer's right. Okay. Then the next aspect is, how does an infringement of copyright occur? Please give me a moment until I drink water for once. Just give me a moment. Okay. Yes. So the next aspect is, uh, how does an infringement of copyright occur? The infringement of copyright occurs if anybody, without the permission of the author or without a license or without an assignment, goes ahead and exercises any of the rights which we just looked at under Section 14 of the Copyright Act. Okay, if you're going ahead, you're doing anything which is the exclusive right of the owner of the copyright, then you are infringing the copyright. Okay, we have looked at what are the different rights that either an author, who is generally the first owner, or any other owner under Section 17, what are the different rights that are provided to them. If you are not the author, you are not the owner, and uh, you are exercising any of these rights, then you are infringing the copyright. Okay, so you are either selling or uh, you are offering for sale any work of copyright. Secondly, you are distributing the work. Thirdly, you are uh, disseminating the work to the public. You are exhibiting the work to the public by way of trade of any infringing copy, or you are importing the work into India, which is again an infringing copy of the work. In all of these situations, since all of these are exclusive rights of the author, if you are doing it without the permission of the author, then it becomes an infringement. Now, when is a particular, okay, before that, we have one important case, which is called the R.G. Anand versus the Deluxe Films. It is a 1978 case. In this case, R.G. Anand, who was a dramatist, he wrote down a play, and the name of the play was Hum Hindustani. Okay. And it became a very, very popular drama. It became a very, very popular play. And therefore, Deluxe Films wanted to make a film on this particular drama. And therefore, they approached R.G. Anand, and they asked him if they can make a play. Then again, things didn't work out between them very nicely. So there was no assignment, or there was no license that was given from the side of R.G. Anand versus Deluxe Films. Now, this Deluxe Films, it went ahead and on the same theme. Okay, it did not copy the entire play, but using the same theme, it made a movie. Later, R.G. Anand went to the court and said that there is uh, an infringement of my work, and I require uh, uh, damages for this particular infringement. The court said that the Deluxe Films has only used the broader theme of what your play was based on, which is an idea and not an expression. Since we do not protect ideas, therefore, this is not an infringement. Okay, what we protect is the expression of the idea. So, if they had copied your entire work and they had adapted your entire work, or they had adapted your entire work, then in that situation, it would have been an infringement. But currently, since they have only taken the broader idea and they have made their own movie, they have made their own expression of that idea, therefore, it is not an infringement, and therefore, there are not going to be any damages that are going to be given to you. Then is one of the most important aspects under the copyright law, which is fair use. Now, we have seen when an infringement can happen under Section 51. Section 52 tells us circumstances in which, even though you are using a particular work without the permission of the author or the owner of the work, it would not amount to an infringement. Such uses of the work wherein the author or the owner of the work, they have not permitted you to use the work, however, you are still using the work, and it is still not amounting to an infringement. Such uses of the work are called fair use. Okay, so in a situation when I have to use the work, even if it means using the work without the permission of the author, whether that work amounts to fair use or not depends on the legislation of each and every country. So, when you look at fair use and fair dealing, these are two different aspects. Fair use is much, much more broader than fair dealing. Now, if you look at the legislations, if you look at the countries uh, which are basically using the fair use um criteria, they have given a very broad uh, exception to it, which means that they have not laid down that only for these purposes can you use the work without the permission of the author. What US has done rather, that it has given down four criterias. Okay, four factors which have to be considered when the court is deciding whether a use amounts to fair use or not. The four factors are: one, the purpose of the use. For what purpose are you using it? For example, if you're using the work to commercialize the work, then it is not going to be fair use. However, if you are using the work just for um, teaching purposes, then it may be fair use. So, what is the purpose for which you are using a copyrighted work? Second, what is the nature of the copyrighted work that you are using? Third is how much of the copyrighted, what amount of the copyrighted work are you using for your purpose? And the fourth is how badly is it affecting the market of the author or the owner of the work, whose work you have been using. All of these four factors for any use of work that you are doing, The court is going to apply these four factors and see if your work is fair or not. This is how fair use it is dealt with under USA. Now, when you look at fair dealing, which is a narrower concept, and it is used in India and UK, there are certain purposes which have been defined under law. Okay, so law says that only for the purposes of, say, private use, or only for the purposes of research, or only for the purposes of education, only for the purposes of criticism, only for the purpose of review, you can use any other person's work. This is what fair dealing says. US has not told us uh, uh, what are these uses, right? It has only said that any use which satisfies these four criteria is going to be fair use. But that is not the case in India or in the UK. What we say is 1, 2, 3, 4, 5. Only for these purposes can you use the work of any other person. Okay, and not for any other purpose. If you look at UK for that matter, UK still has a much more broader fair dealing provision than India does, because there are discretionary provisions that are mentioned in the UK legislation. However, if you look at the Indian legislation, it is again a closed list, which means that there are certain things given in the list that only these will amount to fair use of a given work. Anything which falls, any use which falls outside the scope of the work that we have given out to you, it is not going to be fair use or fair dealing for India. Okay, so section 52 of the Copyright Act in India, it gives out it gives out a list of things uh, which is going to amount to fair dealing in India. So section 52 is very, very long, 3, 4 pages long section. So we are not going to go into all the subsections. I have broken it down for you, and these are the most important aspects. Okay. So if you are using a work for private or personal use or for research purposes, then it could be fair dealing under the Indian Copyright Act. If you're using the work for criticism or review purposes, you're using the work to criticize the work itself, or you are using it to criticize any other work, then it could be it. Then the third could be review. For example, you might have seen that there are different people who are reviewing movies on Instagram these days, right? So what they do is they kind of take excerpts from the movie which is playing in the background, and they are speaking, right? So to review the work, you are using the work which is allowed under section 52. Then if you are reporting the current events, just like I told you, just like the broadcast example that I gave you, the DD example. Um, Similarly, if you are reporting any current event, you can use a work which belongs to somebody else. Then in any judicial or legislative proceeding, for example, there is a case going on, in that situation, you can use or reproduce the work of any other person. As a teacher, for any educational use, I can go ahead and use portions of a work, either for classroom teaching, for preparing questions of examination, or for uh, any other purpose which is educational in nature. I can use it. Okay. Now, to keep the work in a library for preservation purposes, because again, remember, the end aim of copyright is to ensure that the work is accessible to the people at large. So until and unless you are preserving these works in a certain library or at a certain place, you cannot ensure that these works are accessed by the people at large. Then any transient or any incidental storage. For example, uh, say there is a cricket match that is going on. There is a little delay in the cricket match, if you know why. Because the match is happening there, camera is capturing it, and it is incidentally getting stored for a little amount of time, maybe 2, 3 seconds, and then it is being pushed to your server, and it is being shown on your screen. So the actual live match that is going on and what you see at home, there is a 7 to 10 seconds delay in that, right? And between that, this uh, this broadcast is being stored incidentally on different servers before coming to your place, which is allowed under section 52. Then, in order to make this work accessible to specially abled persons, again, if you are adapting that work, then that adaptation is allowed. Okay. Um, Now, this one very important case, which is India TV Independent News Services Private Limited versus the Yashraj Films Private Limited. In this case, there was a show that was being broadcasted on TV, and it documented the lives of singers, wherein these singers were performing, and they were performing their own songs. Okay. However, these performances were basically clips from a particular movie, and they were shown at the background. Okay, so for this documentary, their excerpts of the movie were taken and they were being played at the background. So Yashraj Films, who was basically the owner of all of these films from which the excerpts were taken, uh, Yashraj Films claimed that this particular act amounts to an infringement of their copyright in the work. However, the defendant said that this amounts to fair dealing under Section 52. Uh, the Delhi High Court said that you are using the work in order to commercialize the work. Okay, so you are making a documentary, you are not reviewing the work, you are not criticizing the work, you are commercializing the work. Okay, so because you are commercializing the work, it does not amount to uh, fair dealing under Section 52. Also, the use that you are making is not mentioned under Section 52, and therefore it does not amount to fair dealing. Okay, then another very important case is the Chancellor Masters. Okay, sorry. One case that we missed in between is Civic Chandran versus Amini Amma. In this case, the court said that even though a use is allowed under Section 52, we are going to look at three things. Okay, what is the quantum of the work that you are using? If it is if it is say a 2 hour film, and I am reviewing a film and then showing all 2 hours to you, does it make sense? It does not make sense. So even though review or criticism is allowed under Section 52, we are still going to look at what is the quantum of the work that you are using, what is the purpose for which you have taken, for which you are using the work, and what is the likelihood of competition between the work that you are generating using the previous work and the previous work itself. So if I am showing the entire 2 hours movie before reviewing it, everybody is going to see the movie in my review video itself. Nobody is going to go out and see the movie in the theaters, right? So therefore I cannot use the entire film, one, and two, there is a likelihood of competition between what I have created and the work that I am using in order to create my own piece of work. Then the last case is the Chancellor, Masters, and Scholars of the University of Oxford versus Rameshwari Photocopy Services. This is also called as the Delhi photocopy case. Uh, Now, in this case, what happened was there were several books which were owned by uh, different institutions around the world. For example, books were of Oxford University Press, then there were books of Cambridge University Press, then there were Taylor and Francis books. All of these books were there. And this small photocopy shop outside the Delhi University, what this shop did was it took excerpts from each of these books and created a reading material for the students. Okay. Now, uh, although it was a reproduction of these particular books, only 5% to somewhere between 5% to 33% of these books were taken by this person, and uh, were and this particular use was for nothing else but to create an educational pack for the students. So the court said that this amounts to fair dealing under the Indian provisions. The reason is that this person has only taken excerpts from the book, one, and two, it is for educational purposes, which is allowed under Section 52 of the Copyright Act of India. Okay, now in this case, one important aspect was that the court did not comment anything on can we reproduce the entire book for educational purposes. So can you photocopy an entire book for educational purposes? This was not answered in this particular case. Now, coming to the last aspect of today's lecture, actually, this is not the last aspect. The last aspect is the digital rights management, which I am just going to touch upon. The reason is that we are living in a digital era, and now you should know what are the different digital safeguards under the copyright law. But before that, let us come to remedies. There are three kinds of remedies that are provided under the Copyright Act for any infringement of copyright that takes place. The first is civil remedies, second is criminal remedies, and third is administrative remedies. When you look at civil remedies, there are uh, uh, five types of civil remedies which are provided: injunctions, damages, rendition of accounts, uh, delivery and destruction of infringing copies, and damages for conversion. Now, injunction is to stop somebody from doing anything. Okay, so injunction is basically nothing, but it is sort of a stay order from the court. Damages are basically compensation for infringing your copyright material. Rendition of accounts is whatever profit you have earned by commercializing my work, that was essentially my profit that you by infringing my work have gained. So now you return those profits to me. This is rendition of accounts. Then delivery and destruction of infringing copies. Any infringing copies that you are holding as an infringer, those all need to be either delivered to me or they have to be they have to be destructive altogether. Okay, and then damages for conversion. Any conversion that you have made of my particular work, for that also you give me compensation. Okay, now we are going to look at certain types of injunction uh, in very brief, which are relevant for copyright, and then we go ahead. The first is interlocutory injunctions. Interlocutory injunctions are nothing but which are given while the case is going on. So before the end of the case, when an injunction is given, it is an intermediate injunction which is provided in the middle of the case itself, before the case ends, until the case ends, I'm sorry, until the case ends, you are prohibited from doing this act. Okay. Then pecuniary remedies, I have already told you about account of profit, about compensatory damages, and about conversion. All of these things I have told you. Then there are ante pillar orders. Now, ante pillar orders are basically uh, restraining the defendant from destroying or infringing the goods. Okay. Uh, Second is that uh, it is a search and seizure order also. And the third, it is a group of different things. Ante pillar orders are group of different things. So the first in the group is restraining the defendant from destroying or infringing the copyrighted goods. Second, the search and the seizure order. And the third is disclosure of the names of the suppliers and consumers of the defendant itself. Okay, then you have Mareva injunction. Mareva injunction uh, is an injunction which is given to the defendant when the court feels that the defendant is trying to either delay or obstruct the execution of any decree which the court has passed. Okay, and then we have the Norwich Pharmacal Order, which is basically nothing but an order which is given by the court in order to take information of third parties. Only such information which can be discovered from third parties you want to get. from Norwich Pharmacal Order. Then you have criminal remedies, imprisonment of 6 months to 3 years, a fine of 50,000 to 2 lakh rupees, search and seizure, delivery of the goods, and any kind of enhanced penalty which may be there for subsequent convictions. So more than once, if you are infringing, then there might be enhanced penalties. These are all criminal remedies. Then administrative remedies has border measures. Basically, if you're trying to import something from outside the country, then the customs authority is going to stop that import. Okay, these are border measures which you are basically applying at the borders of the country. Then now we come to the last aspect of today's lecture, which is the digital rights management. Now, if you want to understand digital rights management, you understand it as use of any technology in order to preserve your work, in the sense that you can control the work, you can control the access to your work, not let anybody access your work, and thereby stopping the infringement of your work. Okay, very simple example I will give you. When you look at a movie, when you see a movie on Netflix, you are not able to either screenshot it or screen record it. It is not allowed on Netflix. Why? Because it is a digital rights management uh, procedure which has been used by them in order to control the access of the work by any person. So you can only look at the work, you can only see the work, but you cannot um, and record the work with you in any manner. This is digital rights management. Now different countries gives different types of digital rights management. In India, what we have given is technological protection measures. Okay, this is one of the type of digital rights management. The example that I gave you of Netflix is actually a technological protection measure. You are technologically protecting the work uh, which is in your possession. Okay, so Netflix has possession of all of these works, and it is technologically protecting our access uh, to the given work. This is a technological protection measure. Now, if you look at India, Section 65A of India, the Indian Copyright Act, uh, basically says that if anyone tries to circumvent any of these technological protection measures, there is going to be a criminal liability that is going to be laid on them. Okay, so you cannot circumvent any technological protection measure uh, in any sense. However, what you need to understand in the Indian uh, Act is that they do not completely prohibit the circumvention of technological protection measures. They allow circumvention if circumvention is not per se illegal. For example, if you are circumventing uh, any technological protection measure in order to make a fair use of the work, then it is not going to be a criminal liability on you. Okay, so that is allowed. However, if you look at USA, if you look at UK, all of these countries, what they have done is they have blatantly applied the technological protection measures, the digital rights management rules, and said that any circumvention is going to be uh, criminal in nature. So even if you are circumventing for a fair use purpose, even then it is going to be infringing, it is going to be criminal in nature. Okay. Therefore, when you look at the Indian law, it is much more progressive and it takes into account the fair use provisions also. Okay. Under Section 61A, there are certain criminal remedies which are laid down. So there is a punishment of uh, of a maximum period of 2 years, and also an imposition of fine with respect to any circumvention of technological protection measure which may be there. Okay. And if you are in an unauthorized manner removing or altering the technological protection measure completely, then also you may be imprisonment, you may be imprisonment, you may be imprisoned. I'm sorry. you may be imprisoned for a period of maximum of 2 years, and you may also be compelled to pay a fine. Okay, that is it from my end. If there are any questions that are there, I will be very, very happy to answer. And if there is anybody from the committee, then it would be really helpful if you could. Yes.
Uh,
Thank you,
just
ma'am.
looking into the question answers, there are no such questions coming up. If anybody has any question, they may write in the box and we can get it. Till now, there are no such questions. Uh, let's wait for 1 or 2 minutes. Uh, See, the only question which is coming as chartered accountant to us is that what role can CAs play in advising businesses on copyright compliance and risk management?
Ma'am, as far as I know, a lot of my friends are CAs also, and they also, when they were preparing for CA, I helped them with the IPR aspect of it. I'm sure that there are, even in CS for that matter, there are copyright aspects of, sorry, there are IP aspects in both CA and CS courses. Now, a lot of times nowadays, what is happening is companies are hiring CAs with the intent that they are also going to do the job of a lawyer, because to a lot of extent they know law. So companies hire CAs with the intent that these people are also going to do the job of a lawyer for us. So when you look at all of these acts, the Patent Act or the Copyright Act or the Trademark Act, which are the most important IPs, uh, CAs can definitely, advise the companies with respect to what may amount to an infringement of these. How can you stop the infringement of these works, especially with respect to trademarks? If you are talking, then go ahead and register your trademarks. How to register these trademarks? What are the forms that needs to be filled? All of these things by basic understanding of IPR laws, and specifically because I have also been taking certain classes on the certificate courses of IP. So I know that they are being trained on how to, utilize these IPs and how to sort of advise the companies with respect to the different criteria of protection, with respect to the different forms that the companies need to fill, with respect to the different due diligences that the companies need to follow in respect of each of these IPs. Very, very important for CA.
And one more question, like how Copyright Act is interrelated with trademarks and patents?
Okay, ma'am, actually, Copyright Act is a very separate legislation. If you look at the Patents Act, if you look at a Trademarks Act, you will see that they have specifically said that anything which is a subject matter of copyright, we are not going to protect under Patents Act or Trademarks Act. So all of these different IPs, uh, they are very, very separate and they are very different. So they have absolutely nothing to do with each other. The only thing is all of these, they fall within the umbrella term intellectual property. That is it. However, what is protected under each of these is very different.
Okay, one question has come
Yes.
from Niranjan Ojaji. He's asking, would the copyright application made be considered as intangible rights of the applicant? What happens if the person has made IP, that is copyright trademark, while working for a business entity? Then does the company deny its claim to the individual who created it?
Okay, so this is the exact thing that we have discussed under section 17 of the copyright. It depends on the kind of agreement that you have had with the company and the kind of employment that the company has engaged you in. For example, you have been employed to create a particular copyrightable work for the company, and then uh, uh, the company is claiming that the copyright is there. Company is absolutely right, because the company had hired you to do a particular work for the company is paying you, and uh, that work that you have made, although you are the author, the company becomes the owner of all the rights that you hold in that particular copyrighted work. So it is absolutely right that whenever a company is hiring you, it depends on the scope of your job. If, say, I am working as an IT professional in a particular company and I am writing a book side by side, okay, my job profile does not say that I have to write a book. And therefore, the book is going to be my work. All the rights also I am going to hold in the book. However, if I have been hired to write a book for the company and then I write a book, in this situation, the company is going to be the owner of the work, and I am merely going to be the author of the work.
There are no such questions popping up right now. So can we conclude the session? Yeah. So let me give a vote of thanks on behalf of my committee. As we have come to the conclusion of today's webinar, I, on behalf of the Commercial Law and Economic Advisory Committee of ICAI, extend my heartfelt gratitude. I also express my appreciation to the committee for organizing this knowledge enriching session, for their continued efforts in creating awareness and professional opportunities for chartered accountants. A special thanks to the participants for joining us in this evening and making webinar interactive. Thank you, ma'am, again for your deep, insightful information and knowledge which you have shared with us. Thank you once again and wish you all a pleasant evening ahead. Thank you.
Thank you, ma'am. Thank you, everybody. Good day.